Take two. Take two.
Oh, it's on. It's ready.
All right, I'll start. In what ways was the Voting Rights Act of 1965 similar to and different from other civil rights legislation of the era? In particular, how does its focus and approach to enforcement compare with those of the Civil Rights Act of 1964?
So the motivations behind the Civil Rights Act and the Voting Rights Act were exactly the same. They were both out of the Civil Rights Movement and both attempting to create equality between African Americans and their white counterparts, which had not been up to this point, and using the enforcement clauses of the Reconstruction Amendments from the Civil War.
Additionally, President Lyndon B. Johnson, as well as Martin Luther King Jr. Worked together to draft the Voting Rights Act. So they worked in concordance, and through this relates directly to the Civil Rights Movement and the political issues of the time that they were directly addressing by reinforcing the 15th Amendment and stating these in the Voting Rights Act.
When do you think in history, in our history, was it the easiest for people to vote? Provide examples and be specific.
I would say that 2012, or just previous to that, would be the easiest time to vote. And my reasoning for that would be simply because at that point we had all of our voting amendments in place. However, we did not yet have the Shelby v. Holder decision, or Shelby County v. Holder decision of 2013, which has ultimately disenfranchised millions of people across the United States. For example, in Texas alone, approximately 800,000 people do not require the necessary ID to vote that had voted in the previous election. And so 2000.
So you think we're going the wrong direction?
Yes.
Anyone disagree?
I would argue that prior to the 14th Amendment, and in earlier times, when the Western United States and expansionism was still happening, then states could decide who could vote in elections, and many women pre-19th Amendment were voting just because there was so much land to be inhabited and they had the stake in their society.
I would argue that the easiest time to vote was when the only voter requirement was to own property. If somebody simply owned a donkey or even a small piece of land, they were eligible to vote.
So it was easy for them to vote.
Yeah, should
Yeah.
vote.
I want to shift to, there's been a lot of discussion about the integrity of elections recently. Colonel, thank you. But a lot of it is this alleged interference, I say alleged very loosely, by the Russian government in our electoral process through the release of documents like through WikiLeaks, etc. Is that really tangible, concrete electoral interference? Because we can be influenced by a lot of different things. We still have to make our own decision when we go to the ballot, right? Go to the ballot box. So is there a case for saying that simply releasing documents to influence the populace is an act of voter interference?
By releasing documents and having information out which in the marketplace of ideas, then this is protected. This is protected speech, and so people choose what they like to subscribe to and what they read and what they are interested on the internet and in media alike. So through this, we are influenced, but we have our own personal opinions that we form because of these and what we take from these sources.
I'm going to disagree. Those who want to be educated voters, who take all of the information that's available to them before making their decision, may not be able to distinguish between what may be considered fake news, what may be real or fake documents released allegedly by Russia. And so what we can see is that people who are trying to be informed, are trying to make the right decision, may be incorrectly swayed and not make the decision that they would have made otherwise, and in that way is directly affecting our electoral process.
What is preclearance in the Voting Rights
So we can see the future, right? Oh, that's clairvoyance, sorry.
Under section 4B of the Voting Rights Act, it states which states must fall under section 5, which is the pre-clearance section. In this, those states named in 4B must get direct approval from the federal government before changing any of their voting laws. The purpose of this is ultimately to determine if any of those laws are going to be discriminatory, and actually a number of laws have been shut down because of pre-clearance that were ultimately passed after Shelby v. Holder.
The Declaration of Independence says that we are all entitled to the pursuit of happiness. Where in the Constitution or in any court cases have we been guaranteed that right?
I would argue that the term "the right to happiness" is very loosely defined, and that a personal opinion of what happiness is greatly different. But in the Democracy Restoration Act, there's a quote that voting is the is the only way to fully reach equality and citizenship. And through this, because the founding generation was so adamant on having voting as part of a way to secure the people's voice and have them be heard and represented, then this is a way to obtain some form of happiness because they are being represented.
John Bing, Dave, you have gone yet, have you? You go?
Yes.
I'm going then. Okay, John, you're so coy about it. So John Bingham's statement that citizen or stranger alike deserves protection under of constitutional rights of the 14th Amendment. Is it fair that, let's say that Ramzi Youssef, who was accused of being involved in the original World Trade Center bombings, he received a civilian trial in the Southern District of New York. Is it fair that somebody who doesn't pay taxes into our country gets to enjoy the taxpayer subsidized fair trial? Is that is that a fair concept?
I would argue that it is not a fair concept. If somebody is pledging their allegiance to a foreign nation or entity, then they could be prosecuted in a military court where they are not granted the trial by jury or.
I'm going to disagree with my colleague. We can see that there are cases where a direct act of war can be tried in a military court. However, if it is a civilian crime committed by a civilian, not necessarily a soldier, it should be tried in a civilian court because the 14th Amendment directly guarantees due process to all persons. And that is not discriminatory of necessarily people who are residents of this country or not. Illegal immigrants get their full due process rights, and that was John Bingham's original intent with that.
Now, can I ask?
Thank you.
You may.
It's been said that through its wide scope and promise of equality, the 14th Amendment created a new constitution. Do you agree or disagree with this statement, and why?
I absolutely agree with that statement because through the 14th Amendment there has been the incorporation of the Bill of Rights to the states. Before this, under Barron v. Baltimore, none of the amendments applied to the states whatsoever, and it completely changed our federal system with the 14th Amendment and the Supreme Court cases that followed.
I would disagree with my colleague because though the 14th Amendment and Section 1 very much so changed the structure of our federal system in limiting the state power and applying this through the incorporation doctrine, the other following sections of the 14th Amendment were proposed by radical Republicans who just wanted to, I guess,
Punish the South.
The 24th Amendment was ratified the same year the Voting Rights Act passed, and it banned poll tax. How important was it to establishing voting rights for all?
Poll taxes were extremely discriminatory, specifically to the fact that while there were laws that limited certain voting based off of race or other characteristics, poll taxes were something that did not necessarily discriminate that way, but actually disenfranchised an entire class of people. And so directly stopping this made this a right or privilege that was available to everyone, no matter their economic status.
However, even though the Voting Rights Act essentially provided the right to vote for all, there is the implementation recently of voter ID laws, which can be compared to the modern poll tax issue. So essentially, even though the Voting Rights Act does, or the 24th Amendment outlaws poll taxes, we still have the issue of voter ID laws currently.
Which can cost as much as $25.
And that's the connection between the poll tax and voter ID is the cost.
What do you think about Justice Davis's statement about the Constitution applying fully in war and peace, and the fact that presidents typically ignore it? Is it justified in some cases, all cases?
Craig's been saying that loud.
Yeah, I had to think a little bit. These guys are so smart.
While presidents have ignored the statement that the Constitution should always apply, we disagree with that action and I do agree with the fact that the Constitution should always apply. However, we can see that when we do have congressionally approved martial law, it does take away the power direct from a sole individual completely ignoring the Constitution. And so in a dire need situation, we can see that, for example, within the Civil War, they ended up having to go towards a congressionally approved martial law in order for it to actually be constitutional, because the only direct mention of a martial law-like situation is congressional power, not presidential power.
The all circumstances in all cases part of Justice Davis's opinion can relate to detainees held in Guantanamo Bay as all persons under territorial jurisdiction, excuse me, are to have their 14th Amendment rights and equal protection of the laws. This includes their due process, which is why they should have at least they should at least be heard in a military tribunal, because this still does allow for them to have their due process and petition for habeas corpus.
Are you saying those people are military, should be treated like POWs?
Actually, a prisoner of war would not have any trial according to the Geneva Conventions. The unlawful enemy combatant status that the suspected terrorists hold in Guantanamo Bay allows them to have the writ of habeas corpus and a military trial, which a prisoner of war actually would not have.
What's the difference between POW and enemy combatant? I want to ask you, I'm going to give you a jump question. What is, so habeas corpus can be suspended under circumstances where there's, where either invasion or rebellion require it. What do invasion and rebellion both have in common? Okay, war, but war where?
Within our soil.
On our soil.
Boots on the ground, right? Okay. What is a theater of war?
In ex parte clearing, they refer to a theater of war as, they refer to a theater of war when referencing the few Nazi soldiers that came to the United States, not necessarily in uniform, but were acting as part of our enemies, even though we were not necessarily had fighting on our soil. And that is where the soldiers, or the terrorists, not necessarily soldiers, would fall under an unlawful enemy combatant status, because they're not necessarily fighting as a soldier in a country's uniform, but simply fighting the United States soldiers overseas.
But then wouldn't they be spies? If they're not in uniform and they're here on our soil, wouldn't they be considered spies? Which could basically disallow them certain rights and possibly lead to immediate death.
It's harsh.
Shot as a spy, unless you're John Andre.
Suspected terrorists are not necessarily always going to be on U.S. soil. They are often moved to Guantanamo Bay, however they can be captured in the Middle East, as the majority of them have been. And so in that sense, they're treated similar to a prisoner of war. However, there is no official declared war happening, and therefore you cannot define them as a prisoner of war, and they've gone to the ex parte clearing definition of an unlawful enemy combatant in order to imprison these individuals.
We're done. Sorry.
We're done.
Really quick, so we're on this question, I'll get my one or two things out. Is just, Brad, you kinda hit on it with what Sam was setting you up for. What you should have focused on more is the country. The reason that terrorists are or alleged terrorists are in such legal limbo is because they're considered stateless actors. And because the Geneva Conventions are these are treaties between nation states, that's to whom they apply. Now, there's customary international law that kind of residually applies to really everybody. And that's where like Common Article 3 comes into play. I would look into have you guys Hamdi v. Rumsfeld and Hamdan v. Rumsfeld?
It's in the testimony.
Yeah.
It is? Okay. Would you like me to put you in contact with somebody who wrote one of the briefs for Hamdan v. Rumsfeld?
Sure, yes, please, yeah.
Uh, I think you guys have a really good grasp of the Voting Rights Act. The reason I asked the pre-clearance question is you should have mentioned that in your first answer when you first got a question about the Voting Rights Act. Because that's what made the Voting Rights Act so effective compared to previous civil rights laws. Like, it stopped discrimination before it happened. And it was challenged initially. In Katzenbach versus South Carolina, the Supreme Court upheld it, and then they reversed that in Shelby County v. Holder, saying things had changed in the South, in the words of John Roberts.
They kept section 5.
But they struck out the formula, so Congress has to rewrite and decide again which states are still discriminatory. Also, I know the martial law question's hard, but there's important things to look at there. With regards to Congress having the power to declare martial law, there's two statutes, and they're both old. The Posse Comitatus Act, which limits the use of federal troops for law enforcement on non-federal property. There's also the Insurrection Act of 1807, passed under Thomas Jefferson, that limits federal government's use of the military domestic purposes.
Sounds so much cooler than the Affordable Care Act.
No, so what they do is they send out the National Guard.
Right.
Instead of sending federal troops, although you can't necessarily say that, because in 1907, they sent federal troops to Goldfield, Nevada to put down a miners'
Wasn't that
strike.
because we didn't have a guard?
We didn't have a state police, and so because we didn't have a state police, and at that time there was no Nevada National Guard, they sent federal troops, which would be in violation of your,
But you can send in federal troops if the mayor or the governor asks for it.
and that's what he did. That was Governor Sparks.
Another
Hey, I grew up in the city.
question
So did I.
to consider, we were talking about spies like the German saboteurs in World War II. Spies in peacetime are usually tried in civilian courts. You know, espionage is
Julius and Ethel Rosenberg.
federal
Yes.
crime. It's
Well, were they?
espionage and treason are the only things you can be executed for without killing someone.
Executed for without killing someone. Usually when you execute someone, you kill them. How can you say that?
Well, you can commit the crime, not kill anyone, and still get executed for it, is what I meant.
Yeah, I know. Just the way you said it. You know.
Yeah, wording.
You cannot be executed without being killed.
So think about that, because like in wartime, you know, we have the enemy combatant issue, the prisoner of war issue. There's also a kind of a tradition to shoot spies on sight, like in World War I.
Civil War,
Yeah.
Revolutionary War.
A couple things I have, need to hear it from everybody, balance across the board. El Chapo just got extradited about 20 minutes ago, and he's another guy who didn't pay taxes, and he's gonna be tried in American courts. That's just another example.
I wanna watch that circus live.
Be careful when you go on the Geneva Convention, you better know it cold. You had
See,
better,
Robert is
the Geneva Convention expert, because I'll tell you what, you guys are getting in some murky waters on what's a declared war. I mean, there's a lot of things you can pick on your cross-ex on that. No, if you're gonna go to Geneva Convention, because somebody might know it really well.
Did we
as
say
you do.
anything that was incorrect that we need to fix?
Yeah.
On
Well, is this a declared war? Are we in a declared war right now?
Do you know when the last time we had a declared war
I would
was?
actually say that, I would say that it's incorrect to state that a prisoner of war, that you have to have a quote-unquote declared war.
Yeah.
According to the domestic definition. Internationally, a state of war is simply just a state of armed conflict, of belligerence.
And so it's not a declared war.
Right.
But is that between states, is what you're
Yeah,
saying?
between states. Now, the question is now, did the Islamic State become, did it rise?
Yeah, state.
To the, yeah,
Is
does it
the-
actually be does it have to be a recognized state, or is it, you know, a quasi-state? Is it a pseudo-state? Is it a,
Terrorist group?
What is that? We know that.
They
Of
hold
course.
territory.
But
Other
exactly.
And they
terrorist
call
groups
themselves a
held
state,
territory.
Islamic
And
State.
Let's just call it Daesh
It's
and then we don't have a
territory,
problem.
the definition is territoriality with a functioning government. Now, whether it's a functioning government, that's, but that's, yeah, maybe ISIS is, maybe it isn't. But the fact is that to be a POW, it does not have to be a formal declaration of war in the congressional